thank you so much for sitting down with me today, just to take us through the changes to the Family Law Amendment Act. Tell me a little bit about yourselves and what a day looks like for you at Nicholes.
I'm Sally Nicholes, so I'm obviously the managing partner or founder of this organisation, and we actually have, I'm one of 5 female partners, which we're very proud of, and our day is completely different. You'll think you know what's actually before you, and it will completely change, and we need to be agile because the law itself is actually very agile as well. But we've got a great team. We're a bit different because we actually run quite a bit of pro bono advocacy, and we do it for very vulnerable people, and we're working with great stakeholders like Wire. So that makes it quite a rich day, but probably is standard family law practice.
And I'm Dahl, I'm one of the partners here as well. As Sal said, no 2 days are the same, but also no 2 clients are the same. And I think that's really one of the joys, I suppose, of our job is the diversity of people and the diversity of things that we get to help them with. So it might be working with a woman or gender diverse person who's separated and needs assistance with a financial settlement. It might be working with LGBTIQA plus people starting a family, so surrogacy, sperm donation, or even perhaps grandparents who want to see their grandchildren and aren't able to do that. So it's really, I suppose at the end of the day, helping those people get to a solution and an outcome from the problem in their relationship they're facing.
The Family Law Act is a key legislation when it comes to couples separating, dividing up their property and working out parenting arrangements. There have been some recent changes to the Family Law Act. Can you tell me about those?
Absolutely. So our Family Law Act started in 1975, and it was considered quite groundbreaking at the time because it introduced the concept of no-fault divorce. So there were really good reasons for that. People were really struggling back prior to 75 and having to find fault. So it was an attempt to try and diffuse and be respectful about breakups. But inadvertently, it meant that family violence was actually pushed to one side when it came to dividing property and looking at the financial circumstances. And so really over the years, we've had changes made to the Family Law Act to recognise family violence in different forms, particularly in relation to children. But now it's last year, as of June 25, it's brought in changes to property, which were so important. And what it's doing, it's recognising the economic impact on a partner when there's been consistent, for example, family violence such as coercive control, which is difficult to identify, but it's there, but also financial abuse. And not only what impact it's had on their ability to contribute during a relationship to the assets, but also on the financial reality that domestic violence has caused in the future, and to attempt to actually compensate and be a proper court of equity. So it's really, really significant development.
And I think to follow on from what Sal said, a couple of the really practical changes are, firstly, the court has expanded their discretion to use less adversarial methods of determining property disputes, which is really important. So the court might look at using conciliation conferences or dispute resolution conferences more, or referring people to arbitration, mediation, or collaborative law. Really, hopefully, then coming to outcomes that are a bit more solution-driven and a bit safer. The other big practical change, I think, is in terms of financial disclosure. So the requirement for people to fully exchange their financial circumstances when they separate was always there in the rules, but now it's actually enshrined in the legislation. And the important part of that is, as well as working towards safer outcomes, it's hopefully giving people much more transparent outcomes too, because they're getting a better understanding of actually what there is to divide between them.
So these amendments came into effect in June 2025. How could these changes impact women and gender diverse people leaving a relationship, particularly in the context of family violence?
Yeah, look, I think there's potential for them to really help women and gender diverse people in those circumstances. I think that one of the things that, we're really looking at is people leaving safely and people being able to rebuild financially. And so, look, I think, as Sal said, that recognition of family violence actually in the legislation and as part of the settlement is really important. So things like restricting someone's access to money or running up debt, they're not just relationship issues, they're legally recognised as factors when deciding a property settlement outcome. I think the other thing is the court is now looking a bit closer at those things, as well as wastage of assets, importance of people being able to maintain a residence for them and their children. So I think that those changes altogether really provide an important recognition for people in those situations and hopefully lead them to better outcomes than what they might have otherwise had.
Following on from what Beck said, by treating family violence as a factor in determining the outcome of property, it's really giving recognition for some long-standing behaviours that would and should have been actually recognised. And I think the nuances are, and the reason why there have been the changes, is that we started as a no-fault jurisdiction in 1975, but family violence would weave itself into so many different family law splits. And so to now formally recognise the impact and the long-standing economic impact is really important. Another part of the law, which we think is really close to our heart, and it recognises the bonds between, for example, animals and victim survivors. And one form of abuse that's been long recognised is using animals cruelly in actually as a form of domestic violence. So now the bond between people and their animals, particularly for children, is recognised, and that form of violence is recognised, which is a significant change. And we're talking actually to quite a few organisations such as the vet organisation, veterinary doctors, about that impact.
Following up on what you said, Beck, what approach do you use when dealing with this clientele?
Yeah, I think it's really important when we're helping or working with victim survivors that their safety and their dignity are really front of mind, and also that they're believed. I think the legal strategy is so important, and that's what we do, but I think it all has to be centred around those three things as well. I think that's the most important. And I think also as lawyers, it's being really conscious of some of those lesser recognised forms of abuse. So I think for us, it's about really understanding people's entire experience and what that looked like day to day for them, to be able to then help work through what's a safe plan for them and how is that information important in a financial settlement. And it's also engaging with external counsellors, financial counsellors, people like Wire, to make sure that our clients have all the support they need to go along with that legal system and that legal strategy.
And to follow on what Beck is saying, I think from a legal perspective, that strategy I think needs to be conveyed in plain language, but also to working with support systems such as Wire is crucially important.
Service users have often expressed to us feelings of overwhelm before meeting a family lawyer, or they feel uninformed about the legal process, about what they can kind of expect when they might enter court. What are your sort of suggestions to help them feel more prepared?
I think firstly is to be kind to themselves, perhaps even bring a support person along. There are some difficulties occasionally in relation to legal professional privilege, but we can talk them through that. But actually be prepared to maybe bring somebody for an initial conference and talk about that with the lawyers, but also bring financial information. And so we, particularly when we have first calls with clients and book in, we've got some fantastic intake people who will go through the type of information that might be relevant. But also if they don't have it, just to be reassured, there are ways we can get the necessary information, but just to maybe build a chronology is a really good first start.
And I think for me, it's about taking some time and thinking about what's actually worrying you the most. And that can be different for everyone. So for some people, that might be keeping their home. For some people, it might be making sure their school fees are paid or different other things. And as a lawyer, it's really important that we can walk away from that first conference knowing that we've hit those issues that are most important to you. I think the other thing too is keep in mind you don't have to know everything the first day. As Sal said, as much as you can is great, but if you don't have the answer to everything, that's really okay. And don't put pressure on yourself. Part of our job is helping explore the process and working out what information we need and how to get it.
Also, to add on from there, no question is too silly. So please ask questions. That's what we're there for. So we actually ask people to think about, yes, the priorities, but also don't be afraid to ask any questions too.
I think the other thing too is that often a lot of my clients who are LGBTIQA+ or might come from a culturally or linguistically diverse background can be a little bit worried about approaching a legal service and making sure their relationship's understood. So I think it's about feeling comfortable and making sure you're comfortable with your lawyer and that you feel that your family is understood, because every family is different, every legal situation is different, and you need to be really comfortable in that space that your lawyer understands who you are and what you're trying to achieve as well.
One of the biggest challenges that we hear from service users when approaching separation is people being deliberately obstructive and uncooperative in order to draw out legal proceedings. It makes women and gender diverse people vulnerable to financial hardship and further economic insecurity. What tips or advice would you give to help them to protect their rights and entitlements where they are experiencing ongoing family violence through this?
And I think that can be a real fear, and it can make people reluctant to engage in the system or to pursue what they might be entitled to because they've got that worry on top of it. I suppose my number one tip is to get the support that you need in that process. So whether that's having a lawyer, but also having scaffolding of counsellors and other professionals that can help you through the process. And also really speaking with your lawyer, I think, about that, because there's often things we can assist with, whether that's protection orders or court orders that have specific timeframes or other things, to really do what we can to help resolve that being a problem on top of everything else.
Also, one thing we'd love to reassure clients about, and we've worked with Wire about this now for some years, is identifying the fact that there might be systems abuse going on, and that is a real thing to be afraid of, that people use the legal system as a form of family violence or almost to keep that really toxic interaction going. And now we've got legislation that's specifically recognising it, but also too, it's an offence for a solicitor to actually use or issue applications that have no chance of being successful. And we were finding, for example, there was actually a plethora at women's legal services of violent partners and perpetrators issuing proceedings to actually try and have their children, for example, with them full time, which was such a threatening and scary thing to happen. We've been working on those issues now for years, but now we have more direct ways of actually tackling that form of systems abuse. So I think it's something we really want to get out there, that these type of behaviours do have consequences, not only for the perpetrator, but also be recognised as a form of family violence, but also for solicitors, and we hope they're obviously in the minority, who might actually indulge that type of behaviour. And because it is actually an offence, a disciplinary offence, to actually perpetrate systems abuse.
So lastly, what preventative strategies can women and gender diverse people use to maintain financial security and autonomy before starting a relationship that might involve joint bank accounts or shared parenting arrangements down the line?
That's a very good question. And it's something that we often wish we'd found people before the relationship broke up so we could actually help manoeuvre in that way. It's a difficult conversation sometimes to have with a partner, but I think it's something that I've been speaking to a few schools about, to young women in particular, about maintaining financial independence. So perhaps also making sure that you've got your own independence in relation to being quite aware of bank accounts, having those hard discussions about how the finances are going to be organised, perhaps seeing somebody before the relationship takes off in that way. I think it's also maintaining your own agency in relation to perhaps having a written agreement. So you can have what was known as prenups, now are binding for both domestic relationships, de factos, and also for married couples. So that's something where relationships can be organised in that way. But I think it's making sure that that power imbalance is actually not uneven, and not being afraid to ask the hard questions. But there are definitely legal tools that we can actually help people with, but I think it's having those difficult discussions beforehand. It's really not unusual for us to see one party who says, I really don't know what's in our bank accounts and I don't actually even have access to them. So looking out for those red flags too, there should be transparency. And if you're not provided the access to your joint accounts, for example, there's something that needs to be talked about. And I'm sure that's what the wire phone calls will have a lot of those sorts of agency questions.
And I would just add on to that I think they're conversations that should be had from the outset of a relationship and ongoing, as long as that's a safe thing in the relationship. Because I think that if you talk about expectations, planning, and I think the other thing too is contingencies, right? You know, life is full of contingencies, particularly in a relationship, and things can happen we don't expect. But I think if you can have honest, transparent, safe conversations from the get-go about, okay, if we have children, what might this look like? You know, if one of us takes a career break, what might this look like? And really be on the same page, because I think then if it does come to the point where you separate, I think that you're coming to it with a really good basis of what you both feel about where you are going in the future.
Well, thank you, Beck and Sally, for taking us through the changes to the Amendment Act. I'm sure this will bring a lot of valuable information to the people that are approaching separation, particularly in the context of family violence.
Thank you. Our pleasure.